Mr. Vice Chairman, I'm Dave Domina, D-O-M-I-N-A. I'm a lawyer. I'm helping Knox County out on some issues related to hanger-on matters from LB 1048, but my scope here is beyond that work. My interest in these bills today is because of my work for Knox County over some issues lingering as a result of some of your work last year, and that interest led me to look at this bill. I have not read Amendment 369. That will alter some of the comments I might otherwise have made. I wanted to be sure you understood that the language that was substituted here for the list in the original statute describing all depreciable tangible personal property used directly in the generation of electricity using wind as a fuel source appears to broaden the exemption from the property tax. I don't know what the amendment does to that because, as I said, I haven't read it, but the original intent was a broadening intent, I think, pretty clearly. Secondly, it's pretty clear that the legislature has presumed that a viable basis for substituting for the property tax is to use the manufacturer's rating structure expressed on the nameplate as the mechanism for taxing these machines. The federal government does that too, but the federal government has some regulations that define and control what the nameplate rating process is, and I presume that's done to prevent collusion between manufacturers and large purchasers who might otherwise, at the expense of states imposing nameplate taxes, fudge on what the nameplate capacity is. I would urge your committee to give some consideration to that federal definition, which is at 40 CFR Part 73, Subpart F. 40 CFR Part 73, Subpart F. And consider whether that should either be given statutory voice or perhaps regulatory voice under the rulemaking authority that's in this bill. The third thing I'd like to mention to you is that Knox County, I'm certain, I as a lawyer working on its behalf, see the elimination of that credit or clawback provision that was discussed a little bit ago as not only a good thing but an essential thing. Article 8, Section 4 of the state constitution, as I'm sure you know, prohibits the commutation of taxes. It appears to us as though the credit is in fact a commutation. I think that as members of this particular committee, anytime you hear a reference to a clawback against taxes or anything that structurally forgives or shifts or modifies a tax burden after it has become fixed and final, as in a 2009 obligation being tinkered with in 10, or a 2010 obligation being tinkered with in 11, you have to assume you're at serious risk for violating Article 8, Section 4's prohibition. So the fix, if there needs to be one, needs to be one that is clearly constitutionally permissible. We think that getting rid of the credit is a very good thing, and I simply urge you to be cautious about any kind of clawback you substitute for what we see as a problem, and we believe we have an obligation on behalf of the people of Knox County to test in a court proceeding. Let me mention one more thing that's entirely technical, but a little bit odd about this bill and probably too legalistic for a lot of time. Section 3, Part 7 imposes civil penalties, and those penalties include a $10,000 fine for failure to file reports and to do other things. There's a statute now, Section 77-1726, that creates a felony for failure to pay taxes. It's imposed specifically on, quote, corporations or companies. That statute doesn't reach failure to file, and it doesn't reach underreporting, and it doesn't reach untimely reporting. The civil penalty section of this bill does. I think that's desirable, and it might be desirable to expand 77-1726 to assure that the state has even more force at enforcing the nameplate tax against large taxpayers than a simple civil penalty of $10,000, which could be nominal in some settings. The final thing, technical for the review committee, is that Section 4, which provides an operative date here of January 1, 2010, does not appear to be written like typical operative bill provisions. It says the statute is effective or is operative on January 1 of 2010, and you're enacting it, of course, in a subsequent tax year. I'm not really sure that's entirely what the drafters of the bill meant, and it might be appropriate to consider a technical amendment there. Pardon me for the legalese, and I appreciate your attention.
Questions for Mr. Domina?
Thank you.
Thank you very much for your testimony.
Madam Chairman, I'm Dave Domina. I'll be brief again. My points again are primarily technical as they were on the bill we talked about a few moments ago. I'm the lawyer who's working with Knox County in connection with some matters left over from LB 1048. Again, that work is beyond, this work today is beyond the scope of that engagement, so I'm here speaking for me. But I think Knox County, at least its board, may appreciate what I have to say. Let me say, first of all, let's be completely clear about what this bill does and doesn't do. This is not a question of double taxation. It's a question of mistaken taxation for 2009, but taxation pursuant to a statute enacted by the Nebraska Legislature and signed into law by the governor and the law of this state. That statute created a tax that could be planned for by business, could be accommodated in its planning methodologies and its pricing structures, and made a part of its processes so it could be profitable. That tax became owed to the people of this state in 2009. A long time ago, the people of this state said in Article 8, Section 4, that the legislature of Nebraska shall have no power to forgive taxes or to commute them. A credit that erases a tax which became due in 2009 is a commutation of a tax. That cannot be fixed by subsequent legislation after the tax year ends and the matter has come to a conclusion as to that old tax year. But it can be prevented as to current and future tax years, which is what I think Senator Larson is trying to do, though I've never exchanged a syllable with him about this bill, to be sure that the problem of 2009 does not recur in 2011, to be fixed by the courts in 2012, to result in greater burden on business and more benefit to Knox County ultimately, even though there's some starvation for revenue now. Theoretically, not in terms of good policy, theoretically, what Mr. Pollack said to you about Nebraska cannot impose a personal property tax and a nameplate tax, theoretically that's not correct. Theoretically you could do both. I don't argue that would be good policy. What you cannot theoretically do is to grant a credit to eradicate a tax that has already become due in a closed tax year. This bill, to that extent, is worthy of merit. Thank you.
Questions from the committee? Senator Persh.
So, Mr. Dow, are you saying that that the action that was taken in that purported then to create that credit, that was a unlawful act of the legislature then?
We filed suit in District Court, Lancaster County yesterday contending that that portion of LB 1048 violates Article 8, Section 4 of the Constitution.
Okay. But
and we think you can avoid an issue about that by simply making sure that the playing field is level going forward, but we do not believe you can forgive my income tax due in 2009 or change my tax rate for 2009 as an income taxpayer or eliminate this tax for 2009.
Thank you.
Thank you, sir.
Further questions? Seeing none, thank you.